So part of being an effective entrepreneur is understanding and utilizing every last resource that's available to you. If you take a look at the handouts that we gave you during registration, you will see a multitude of resources that are available to everyone, including some of our sponsors like the Texas Manufacturing Assistance Center, the Rapid Response Manufacturing Center, the Small Business Development Center, and all of these can provide value in different ways to budding entrepreneurs. And we definitely encourage you to go and speak to them. Most of them will be available to speak with you and talk to you about the resources that they provide during our networking break later on today. So, next up is the gentleman that I was so excited to introduce you to earlier. Walter Bissix is a partner with Bissix and Watson. He's so passionate about working with small startups that he decided to start his own firm. He left a very large firm to work on his own because he wanted to work and provide value for small startups. And he certainly understands some of the pitfalls that entrepreneurs go through on their way to scaling up a business. And he's going to go over some of the things that people tend to forget. So next up is Walter Bissix.
My notes are on the screen, so I'm trying to figure out a way to do this where I can. I'm very excited to be here today. I'm here for two reasons. One is that I think it is very important to the U.S. economy that we be innovative. Everybody talks about that's the U.S. advantage is innovation. And we have so much innovation in universities, and it's so hard to get it out to make a product from it. So that's my focus. Kim, you talked about getting rid of things as part of your analysis. I got rid of 1,000 other attorneys in 15 offices around the world so that I could be in a position to work more closely with smaller companies. The other reason I'm excited to be here is that actually my dad grew up in Edinburgh. He played football for Edinburgh High School and always proudly talks about the fact that his two years there as a guard, his job was to, when they played Mission, to block Tom Landry. And he would very proudly say that I was across the line from Tom Landry for 2 years and I blocked him once. So I'm also excited to help Edinburgh and South Texas accomplish things. I'm going to start, is the middle button up? Yeah. I'm going to start with an unlawyerly thing. I'm going to start with a graph just to kind of give you some context. This is really one that's put together for a university spinoff, but it really applies to any startup companies. And it's relatively simplistic, but I think it really helps you understand that you start here. This line is the value of the enterprise, and you want to get that up here. Uh-oh. What did I push? And it takes time to do that. You start with the research. You get your initial funding to do market analysis and things. You develop it. Hopefully, you get to a point where you have an IPO or a sale of the company. There's also inlaid in that different sequences: the technology sequence, the IP protection sequence, the marketing sequence, organizational sequence, the funding sequence. These don't overlap this whole thing. They overlap differently. But I think you'll have this chart available to you on the website, and it's worth looking at it, I think, to kind of get a sense of what the process is, where am I in it, what do I need to be working on. so I didn't like to use the term top 10 list, so this isn't a top 10 list. I intentionally put 13 things on it so we don't have a top 10 list, but I'm going to jump through some issues that people sometimes don't think about. And interestingly enough, I left patents off because an earlier program I saw of this, there was going to be someone speaking on patents, I thought. So that's not on the list, but much of what's been said about patents really applies to all these issues. There's the legal issue, but then there's the cost-benefit analysis of, in your specific situation, how do you do it? And what are you trying to accomplish with it? The first issue is the one most people usually start with, and that's what type of entity should we create? Each of these charts are going to be a whole lecture, so I'm going to hit them very quickly. But the quick answer to this is if you hope to go out and get venture funding from somebody, and you hope to get this company either IPO or acquired, you want to do a corporation because that's easy, simple, everybody understands it. If your idea is one that's really not your exit strategy, you want to create something, build it for a while, you might have a partner that has some specific investment needs, you were so good at getting people's attention, I'm using your technique. Then you might want to use a limited liability company or an S-corp, and all of that's driven by taxes in your specific situation. But the short answer is, if you're going to spin out some technology, go get some invention and go get some venture funding. Don't waste your time. Start with a simple corporation. Everybody knows how that works. So, second question. The issue of selling stock and how does all of that work? People think they know what founder stock is. You can define founder stock, but it really is no different than any other stock. It's just early on that chart, and it's very cheap. But it works the same as any other stock. Every time your company sells stock, no matter how big you are, you have to comply with federal securities laws, you have to comply with state blue sky laws, and you have to think about the valuation and the taxable impact of that sale. I had two people come in one time and they said, we gave each other 1 million shares as the start of this company. That's because we valued our product at $2 million, so we said we're each getting $1 million to start, and now we want to go sell some more shares for $1 million each. And I said, well, if you've said that this stock is worth $1 million and you just issued it to yourself, you have to pay taxes on $1 million. So you've got to think about these things, and if at the last minute you find out that one of your investors is a brother-in-law from Alabama, you've got to comply with the Alabama blue sky laws, even if it's early on, even if it's a startup, etc. So that's something that people don't always think about. 90% of the time it's not an issue because you're all in Texas. It falls within an exemption that you might not have done the analysis, but you're okay. But you've got to think about it just in case, because there are situations where it can be a problem. Second issue, I told you we're going to jump around. Director and officer insurance. Early on with most companies, this isn't an issue because it's money that's not very productive to what you're trying to accomplish. But if you're trying to bring in somebody important to be on your board, and they have a lot of money and a good advisor, they're going to say, I want officer and director insurance. And so you have to think about that. You have to go get that. If you're hoping to be an investor in somebody else's ideas here in South Texas, and you're thinking about going on the board, you need to think about officer and director insurance, and you've got to analyze it, because you can't just say, oh, we've got director officer insurance, no problem. Because most of the time you get quoted something that's either $100,000 or $50,000. Which you're going to pick? $50,000. A lot of times it's cheaper because There's a fraud exclusion. Anybody that sues a director is going to claim fraud. So you start out with insurance that isn't really going to help you. Most of the time, you're most likely to get sued because of a securities claim in the sale of the company. If your officer and director insurance excludes securities claims, then it really hasn't helped you. So if you have a high net worth, if you're getting involved in a startup company and they ask you to be on the board, a lot of great reasons to do that, especially if you want to be at the board meetings because you've got your own money in this deal. You've got to think about this and you've got to analyze it. Another big misconception in startups is that Kim's from Austin. She probably knows Michael Dell. If she likes your deal, you're going to go tell her, if you just show Michael Dell this deal, I know he'll invest. Look, I'll give you 5% of what he invests if you'll just help me out. Lots of people think they can be a finder. In Texas, if you're not a licensed broker, you cannot be a finder. Most of the times when I tell experienced entrepreneurs that, they tell me I'm wrong. They know they can do it. It's not true. Recently, we have a new regulation where you can actually register to be a finder. It was the first step in a process of trying to help entrepreneurs find paths to money. We don't really need to go through it quickly, but it has to be an individual. You can't have any involvement in the deal beyond making an introduction, and then you can be paid. It's worth looking at. But if somebody comes up to you, I can't tell you how many times I've done a deal where at the last minute I find out that my client is going to pay a finder's fee to somebody, and that undermines your securities law exemption and creates huge problems for you. If you're going to someday try to get bought out by somebody big, they'll see that as a liability and they'll lower the value of your acquisition. I should have said, if somebody has a question as we go, jump in, because we're jumping around pretty quickly, but there'll certainly be time at the end. So finders is a red flag to be concerned about. Another area that I see all the time is trademarks. A lot of misconceptions about trademarks. One of the things I like to do when I get a small company client, a new client, contact me, I'll go look at their website. 9 times out of 10, I'll say, you have no trademark notice anywhere on your page. So, quick things about trademark. Number one, a trademark is an adjective. If you have a great idea for your product, you have to use it as an adjective. You've probably heard about things like elevator lost its trademark protection, Kleenex lost its trademark protection, because they didn't say Kleenex tissue, they said Kleenex. It became a standardized term, and it could no longer be a trademark. When the rollerblade phase came through, you could never see that phrase without it saying rollerblade inline skates, because they were very careful to keep it as an adjective and protect the name. If you want to protect your trademark, you don't have to register it to treat it as a protected trademark. There's some clear advantages to registering, but if you're just starting out and you don't have the money to go get it registered, you can still begin to protect it. And you protect it by putting TM by it everywhere. TM means it's your trademark. And you're putting the public on notice that this is my trademark. R, got too fat a thumb for this. R means it's registered. You don't do that till later, till it's registered. But if you've got a great name for a product, you should start using TM on it and protect it. And a domain name is not a trademark. Usually it's a pretty good hint. If you can go find, if you think up a name and there's no domain name with it, probably nobody has thought that name up before. So that's a good poor man's way to do a trademark search, is to see if there's a domain name. But once you get the domain name, you still need to do some of these other things to protect it. Oh, there was one other thing I was going to say about that. Registration not required. What you get when you register is protection all over the United States, whether you're there or not. And it's all over the United States except where someone else might be using that term. A great example of this, a lot of people don't know this, is McDonald's hamburgers were not in Houston until the late 70s. The reason they were not in Houston is there was a McDonald's hamburger chain in Houston for years, dating back before McDonald's registered its trademark. So it registered its trademark. It was protected everywhere in the United States except where somebody had already been using the name. So they had to buy out the local McDonald's trademark or company in order to move into Texas. So it was smart to register because that gave them everywhere else, even where there wasn't anybody, where they weren't working, etc. So I like to talk about trademarks because people misunderstand it so much. But yes.
Sorry to interrupt. How does internet advertising and websites because it's such a geographical
Well, yeah, I'm sorry. The question is how trademarks on the internet. It really makes it more important to say TM, okay? Because then anyone in the world who's looking at that name sees that you're trying to protect it. You use the TM, and that's not geographically related, because that's just anywhere you want to use that name. If you use you put TM, and you're protecting the name, and you're putting other people on notice.
Does that establish your intent to use?
Well, that becomes a tricky question, because just because people might have accessed your website from Mexico does not mean that you're doing business in Mexico and therefore somebody else can't use the name there. So it gets trickier. But the starting point is, if you never put the TM on there, you've struck out before you've come to bat. Okay. Another thing just to touch on quickly is, if you're going to do a standard venture capital deal, you're going to have preferred stock. You hear about people doing the Series A round of financing or the Series B round of financing. What they're talking about is a series of preferred stock. This is probably 2 lectures, because there are all sorts of rights you give the preferred stockholder over the common stockholders in order to give them an incentive to invest. The one thing I would say here is that the venture capitalists, because they've haven't had a great market in the last few years, have gotten harsher and harsher and harsher in terms of what they want in their terms. They basically want the flexibility to whatever happens, they win. And if you are a funding source, if you're a potential angel investor, that in some ways gives you an advantage over the VCs, because you can come in, you still ought to have preferred stock, but you can be more rational and more deal specific in terms of liquidation rights and dilution rights and some of the other rights you get, and you'll be more attractive as an investor. You'll be more attractive to the entrepreneur, and you can actually get into some deals that the VCs may not, because they don't want to spend any time negotiate it. Here's our deal. It's whatever happens, we have the right if your deal is a sure home run, that's a great deal to do with them. But so understanding the specifics about, as an entrepreneur, what you're giving up to the preferred stockholder, and as an angel investor, what rights you really need and what you don't need are very important. Employees. I've actually got 2 slides on employees. A good business person knows that your success depends on your employees. A lawyer knows that employees are nothing but problems. If you can get your business to work without employees, you're better off, but you can't. So I've just listed a bunch of things to think about in terms of your employees. You need to have in place protections about your inventions. Whatever work they're doing, you want to make sure you're going to own that if that's your deal with them, especially if they're a contract person. You may, depending on who they are and how important they are into the deal and how much you're going to pay them and maybe how much stock you're going to give them to incentivize them to be your manager, you might want some non-competition agreements. In some ways, it's pretty ludicrous to sit down and start up your small little company and start talking about a policy manual. But it is something that you need to do that cost-benefit analysis, and as you get bigger and have a little bit more money, you need to do it sooner rather than later. A lot of the laws in this country, you're in a better position if you had a policy against whatever happened, and you educated your people about that policy. So policy manuals can be very important. And if you were doing a timeline of when to do what in your startup, you probably ought to move that up sooner than you might otherwise think. Especially with blogs, Twitters, and emails and stuff. We all know stories. It is amazing how stupid people can be about what they will put out there that everybody in the world will see. It is amazing to me. And so, I'm from Austin also, including the chairman of the board of Whole Foods, whose father I actually worked for at one time, had a blog, an anonymous blog. He got into all sorts of trouble. The company had all sorts of problems. I mean, even he was stupid. John's a great guy. He's a very interesting person, and he does a lot of things right. But you probably, whether you've got a policy manual against it or not, you probably need to be telling that new employee that you got that's so used to doing all of this stuff, be careful about what you say. Even something as simple as if I'm general counsel of a company and I happen to put on my LinkedIn website that I'm going to be in Tennessee this weekend, people who know my company and know who our competitors are might say, is he over there at work doing a deal to either acquire or be acquired by the competitor in Tennessee? It's something that's very important to think about. The last item on this page, a lot of people don't realize this. It's pretty tempting when you're a startup, you don't have much money, you've just done all this withholding from the employees, and if you can just use 10,000 of that for a month, you can get through this problem. There are serious problems. The board, in most cases, is personally liable for the failure of the company to pay the FICA. Everyone in the chain of command above the person who should have made that tax deposit and didn't is personally liable. I used to make a joke of it. When I was on the board of a startup company, I would start every board meeting with, have we paid all our FICA? Because that was the most important thing in terms of my money before it was, how's our stock doing, how's the company going? That's one that's very important. Do not tempt yourself to do that. Second page of employee matters are really just kind of a listing of things that you need an employee expert to help you with. If you're trying to save money by contract labor, you can end up with wage and hour issues. That happens a lot in the technology arena. We're all concerned about making sure we do the right thing for our men and women in the military, and so you want to make sure, and a lot of these things are notice requirements. If you didn't put the notice up on the bulletin board, then you've got a problem. It's not you're not doing the right thing, as you just hadn't followed all the little rules. In South Texas, obviously, the immigration things, and then hopefully you'll be at a point where you're either acquiring companies or being sold and you're having to close a plant for efficiencies, and you have WARN Act. So just in general, there's a lot of issues with employees, and you need some good advice on that always. Another item in the same category is it says the time is 5:22. I better. Another item in the same category, a kind of cost-benefit analysis, is a lot of the risk of your business can be managed by good insurance. You get a good insurance advisor, kind of have this list of things. Who sees the error on this page? Is everybody paying attention? I sent this errors and omission, and then we got omissions here. I decided this morning when I was going through these slides that I'd already delivered to tell you. I did that on purpose so that you would know that there's always errors and you better get insurance. But another item that people probably have somewhere in the back of their mind, being down here in South Texas, or really any technology that's going to go overseas, there's export control issues that, depending on your product, you better know about. You'll be surprised at some of the things that are on the list that there are export controls over. At one time, there was a big deal about the encryption software, because we didn't want other countries to be able to encrypt better than we could, so you couldn't send encryption software overseas. One item for the university that I usually make a point of is, and I haven't told Jackie about this, is that deemed export. If you have a technology and you're here in the U.S. and someone who is a foreign national comes and looks at your product, that you are deemed to have exported that to the country where their nationality is. As one of my former colleagues says, the border is at his cranium. So most universities, there's an exception for fundamental research, and so most universities don't worry about that. But as you begin to do sponsored research, and as you begin to develop a product that is subject to export controls, you have to be careful about who you're even showing it to. A couple of weeks ago, I was at the Princeton plasma physics lab and took a tour. I had to show them an ID, tell them what country of origin I'm from, and all sorts of information. They knew they had to follow that. The other item, and I don't have the specific sites, but there are 3 or 4 federal lists of individuals who you are not supposed to do business with because of the homeland security issues and other issues. And at our law firm, when we would do conflicts check, part of our conflicts check was to go to the federal websites to make sure that whoever this person was that we were going to bring in as a new client, or whoever they were going to do a deal with, weren't on those lists. And so that's something you don't think about, but you would be surprised if you begin to go multinational with your deal. Quickly, a couple more items. Foreign Corrupt Practices Act, as you probably know, is the prohibition against paying bribes overseas. It is a very complicated analysis, and it is. Thought I had it. Yeah. It does only apply to public companies, but if you're on a ramp up to become public, or you think you're going to be acquired by a public company, at some point in your growth, this tax cost-benefit analysis again is probably worthwhile to begin to put the provisions in your agreements with your overseas distributors and others that comply with this statute, so that it isn't a problem that has to get fixed by the acquiring company. So it is something further down the road for you to begin to think about. Arbitration clauses is something that I always like to look at. I've got a client, two different clients that are working on some technology with other countries, and we start with a non-disclosure agreement, an NDA, and so we've got a great form NDA, and then we say, okay, so we just signed an NDA with these people in Russia or these people in Brazil or wherever, and they breach it. What are we going to go do to enforce this great agreement that I wrote? I mean, you know, you have all the rights. You're very well protected. How are you going to enforce it? So one of the best ways, if you've got some dealings with overseas, is to spend the time to look at international arbitration and how that can work. Our Russian contract, the deal is we arbitrate in the English language in London. In Brazil, it turns out that Brazil is a pretty good country to have arbitration in and to rely on the local courts in. Other places in the world, the International Chamber of Commerce in Paris is usually a good place to have arbitration. So if you're trying to protect your technology, even in something early on like an NDA, you need to make sure you're comfortable with which law is going to apply, where's the arbitration going to be, how are you going to pick the arbitrators, what arbitration rules are you going to use. If it's an intellectual property deal, you don't want the real estate arbitration rules to apply. You want to know what language it's going to be in, what are the rules of evidence, is it going to be like a courtroom or is it going to be informal, and then also if one side or the other doesn't like the result, what's the judicial review? Is it binding arbitration or not? Something very worthwhile to think about. And then I thought I would end on a high note with your little startup. Hart-Scott-Rodino, as you probably know, is the review of large transactions for antitrust rules. So you've now gotten it to the point where you're going to sell it, and these are the numbers that apply to this year. Whoops. Just hit end, I think. If one of the two parties to the transaction has assets or revenues of over $1.7 million, this slide is just for the dreamers in the room, and the other one has at least 12.7. In other words, if both parties have 13 million, then you haven't met these two requirements. But if one is this big, one is this big, and the transaction is this big, then you have to go file and be reviewed by the FTC and the Justice Department. And we usually think of this in terms of mergers and acquisitions, but it is anything. If you're a high net worth individual and you're selling some real estate or all of the real estate development you've been doing over the years, and you're selling it for $65 million to somebody that big, any transaction with these numbers require that. And the reason they're funny numbers is because of the adjustment of the what do you call it, the cost inflation adjustment, whatever. So it adjusts by inflation, so you end up with these funny numbers. And then, but the third situation is, no matter what the size of the two entities, if you've built your startup to a value of over 253.7 million, then you have to be reviewed. So I hope that there's at least somebody in this room that has to go back and look at this when they get to that point in their startup development. That's the presentation. Are there some questions about any of those various parts, or would you rather go to lunch? I've got 7 minutes. I can keep you here, I think. Oh, I should have said that. I've been practicing law in Austin for 25 years. I have an office in both Austin and Houston, and I guess my firm has one in Dallas also, because my partner is up there a bit. I represented UT Pan Am in the Fiber Rio transaction, which is why I got the opportunity to come down here, and I wanted to support the great work. But one of the things I can do in Edinburgh is, if you've got a lawyer that you know and trust but doesn't know some of these issues, I can work with that person to help them with some of the issues. And so I wouldn't have to explain it to you. I'd have to explain it to your lawyer, and then he'd tell you it's okay. So, yes, sir. Right. Well, that's where you have to get an expert in that area. But you're right. I actually, it wasn't my client, but one of the firm's clients actually had some product come from Cuba, and I forget where else, and it got delivered directly to a maquiladora on the border. And so what came into the U.S. was not something from Cuba. It was something from Mexico. I apologize. The question was, as someone who's doing business in Mexico, Mexico can do business with Cuba, but in the U.S. you can't. So how does that issue work? And so the answer is that there's analysis you have to do, and in terms of what's represented at the border, and there's also some issues if you're a big company and you're located in the U.S. and you have a subsidiary in Mexico. That's a different issue, but it takes some specific analysis of the rules. And one of the problems with the export rules, there's what's written down and there's what everybody knows who practices export law, and so you've really, it's very complicated. Somebody told me about the book this high that was the list of the products and what the charges were and what. I mean, it's a complicated area. But one way, exporting or importing something to Mexico and then remanufacturing and bringing it here may make a difference. Other questions? Well, it was great being here, and I had to work for Jackie, and she's a hard taskmaster. She didn't give any of us a break, so we need a break. Those of us that lasted the whole meeting need to go have lunch. But So I'm glad to help, and I'll be around if you want to ask some questions and not have your competitor on the other side of the room know that you're dealing with that problem.